And now for our presentation. We're thrilled to have David back. We're going to spend 60 minutes with him going over this topic, which is brand new to the market. We're excited to have him as always. He's been in the industry and helping us for 25 years, and it's just such a true joy to work with him. I'll now turn this over to David.
Well, thank you, Laura, and thank you to everybody at Hall & Company for doing this. As it turns out, we were talking this morning, and we've been doing webinars together for 10 years, Hall & Company and I, and it's been a great honor to do that. Part of the reason I love it is they challenge me. They challenge me to come up with new material in the marketplace that hasn't always been there, and true to form, that is what one of this program is. Because as we're getting into this, we're trying to take your policy manuals, your internal procedures to that next level, that level that goes beyond the straightforward human resources, tax, benefits part of it, to make it a part of your internal team building, your project success, and the development of your staff. We're also trying to make it a part of the program that really goes into the sustaining of your business. What we're talking about today is exactly what I have just worked through with one of my largest landscape architecture firms, one of the largest firms out there. They have some people departing. And in that departure, they want to make sure that they have preserved the integrity of their client relationships, their business, but with also without building bridges, or burning bridges rather, in terms of what's out there. So as we go through this, consistent with the AIA, we want to really understand that interplay of technology and the intellectual capital. It resides within your staff, within your people, and within your own computers, and how we manage all of that. What we want to do is look at the opportunity that an employment and policy manual plays to take it beyond those core elements that we're going to review here and talk about for a moment, and really make it the basis for how we're doing business, how we're doing our design process, and how we're going. We want to build those core principles to preserve that intellectual work product and business information. That is what drives your business. That's the value of your business, and you don't want that to walk out the door in one way or the other at the end of the day. By the same token, you do want to be respectful, I think, of what's taking place. And we're going to talk that out. And then we're going to talk about how to use this policy manual, this vehicle, as a vehicle to establish consistent professional practices so that everybody in the firm is playing from the same playbook. It's not mandatory, it's not an absolute edict, but it is guidance so that we're all working together in a collaborative context, building towards better practices. It leads to interoperability, it leads to better projects, it leads to a core consensus of how we are going forward and doing business together. As we go through all of this, after we talk a little bit about what goes into a policy manual, kind of the background behind it, we really want to go through kind of 6 core issues that takes us to this second level of a policy manual or an employee manual. We're going to talk about business authority. By business authority, I mean who can make decision that binds your firm or your business, and how do we represent that? We want to talk about performance standards and procedures. That is, as an expectation within your company, how are we doing things? And then what's the process that we are all embracing or using as our starting template for projects and undertakings so that we're doing it the same way? We want to then talk about the ownership and control of that protected business information, client information, contract information, financial information, as well as the design product that you've generated. What's the ownership and control over that in a reasonable and customary fashion? We want to talk about internal and external communication standards. How is it that we are equipping and empowering people to go out there and communicate with the world on the behalf of the firm, and so on, record keeping, and then finally these kind of really complex topics, the ones that can challenge a lot of firms, a lot of individuals, is the competition and moonlighting issues. So we're going to go through all of that, saying that all of that can be built into your policy manuals as in a part of it and take it to that next step. But before we get into that, let's talk about what typically goes into this. So my next 2 slides are drawn from the AIA Handbook on Professional Practice. And in that human resources section, which spans something in the neighborhood of about 80 pages, they have an outline of what they believe the major components of human resource management is. That is, those people who are engaged in managing your human resources, the hiring, the reviews, the reprimands, the benefits, all of that, what their core issues are. And they have 9 of them here. We've listed them here. I highlighted 4 of them in red. The other 5 really go to those traditional HR issues of, benefits, salaries, that type of thing. The 4 I've highlighted really can have some overlap to what's taking place out there in the professional practice in terms of the performance we're going to undertake and where we go. Obviously, performance management being number 3 there is a key component of that. What we find, though, is in the AIA approach, they're talking mostly about reviews downhill, reviewing the work and giving feedback on it, as opposed to really training people up in terms of what's taking place. That takes place later on down in the training and professional development. That's one that's too often gets short shrift. Some firms really embrace it, others don't, but it's something that we really do need to focus on and moving that forward. The other thing we're going to talk a lot about is going to be the onboarding performance process, because to bring somebody on, most firms, what they will do is they will walk them around and tell them about meal breaks and rest breaks and where the restrooms are, where they can eat their lunch, what the holiday schedule is, and so on. But in terms of onboarding somebody and getting them up to speed in the practice and how we want to do business, well, that's really fundamental and critical. We want to talk about that because without appropriate onboarding, we can't really have a standard to measure performance management, the next one, and we don't have a foundation to move us forward into the ultimate training and professional development. So these all really tie together. In terms of the typical employee handbook, these are the sections that come out of the AIA. These are the things that they say should be in there. Again, as you look at that, you will see most of this goes into pure traditional HR topics and things like that out there. They have, I believe, 16 of them here, more or less. What I want to focus on here for the moment, though, is to just talk about the last one, which is acknowledgement. And that is so fundamental and critical at all levels of the business. So when we're doing the training, when we're bringing somebody on board, when we're doing the policy manuals, all of that, to have an acknowledgement of the information taking place is fundamental. Because absent that, it's kind of like, did it happen or not? And to really be formalistic, rigid about acknowledgements initially, as to updates in the information, and then the education that goes behind and into all of that going forward. It really is fundamental to where we're going and all of that, and it is the most important step. We're going to say that a number of times as we go through this program together. So with that in this background, I want to take us beyond these 12 topics that they have here, and I want to take us into that next level, that next phase of how we take employee handbooks or policy manuals or procedures manuals and take it to what can really empower us to do better work going forward into the project. And my screen is frozen here for a second, so bear with me for a second. My faithful sidekick is here to help me get back on track here. Thank you so much. That was Kristen Bernal, who's been my guide for this stuff for the last 10 years, and she did it perfectly there. So thank you so much. So we want to talk about business authority. And what the real concern here is that if you're operating in a firm context, how does the outside world take it? Who could potentially bind you or your firm in terms of what's taking place? And so as we get into this, I want to give you a definition, because ostensible authority is the legal concept we talk about. I happen to be drawing upon the California Civil Code here, but it really exists in every state that's out there. And what it says is, it is ostensible authority means that what a principal, that is an owner or a firm, intentionally or by want of ordinary care causes a third party to believe the agent possesses. So what that means is, if somebody believes that the person has authority to bind your firm and you allow them to have that perception, or you create, or you don't stop them from having that perception, they can bind the firm contractually, and you could be bound by what's taking place in that regard. So as we do that, if you're in a group setting, on your own or whatever, I'd like you to take a moment, talk amongst yourselves, and write it down on a piece of paper. 2 questions. The first question is, who within the firm do you believe can contractually bind your firm to anything? What's the level? What's the category? Who is it? And then number 2, to take a little bit of a moment of self-reflection, what would the outside world think in terms of who could be that person? So we're going to just take a moment, talk amongst yourselves, think about that. Who do you actually want to have that authority? And who could the outside world actually believe has that authority? so with that, I have a question for you. If in your firm you have somebody who has the title on a project of project manager, what would the outside world believe that their authority is? What would they reasonably think they had in terms of entitlement? If you have somebody who has the title office manager, if you have any of those titles out there, what would the real world think in that regard in terms of what is out there, what the authority is? Because that's ultimately the first part of the question. As we get into this, we want to talk about two different sides of it, because I think there are really two relevant business authority sides. There's first the contracting side. There is the contracting side with your client, that person who can enter into an agreement with your client, modify the agreement, take those steps. And then there's the outside vendor, the third party, be it a landlord, be it a contract for services, whatever it is out there. Then on the project side, there is who has the authority to stamp and seal within your firm, and on what basis and when. Who has the authority to bind the firm and even your client in terms of what's taking place, and who has the project authority to direct changes that are out there in terms of what is taking place. So I want to give you an example, particularly with respect to the last one, because it can be very ambiguous. I was once working on a large renovation public works project for a ferry terminal. And in that project, as it turned out, the contractor came back in with about $500,000 to $750,000 in change orders related to some parts of the systems. And as we went through it, and we were sitting there next to our client, the public entity, I happen to represent the architect here on behalf of the team, the conversation was, well, you got no change orders. You have no change directives coming from the architect. You have no basis for this. And at that point in time, they reached under the table and they brought out 3 large notebooks filled with email after email after email from the lower level project team, drafts people up to project manager level, communicating back and forth in email amongst themselves, to the contractor shop drawing representatives and all of that, providing additional information, direction, clarifications, and approving various approaches being taken by the contractor. As it turned out, since we were ambiguous as to who had the authority, that one turned out that contractor got about 65 to 70 cents on the dollar, and more than half of that ended up being paid for by the design team for having provided that information and direction in terms of what was taking place out there on that particular project. The other thing we want to be really kind of clear about is the danger in all of this. If we've not clearly defined the business authority and we're not careful about the provisions that we have out there, how it can bind the firm in other ways. Let's go back to the vendor side of it. Once upon a time, I was representing an architectural firm, and this one happened to involve the lease of their building premises, and they were in the process of considering and working through a potential lease extension. At that point in time, they were a corporation. A corporation has shareholders, it doesn't have partners, but people like the name partner. It sounds important, it sounds lofty. And so they had one of their principals who signed on to a document which was arguably an extension of the lease at a much higher rental rate as with the term partner. And under that, it was argued, and we had to face the argument that it then became, for purposes of that lease extension, a partnership, general liability applying to everybody in the firm, and that they had a personal liability as opposed to suffering the corporate protections and all of that. So again, to have controls out of this really is important. So we want to build a platform for how we put into our policy manual, how we put it through together in terms of what we want to do in this. And so this is not a mandatory provision here. This is kind of a list of options, because you're going to need to find something that is going to work for your firm and how you're going to do it. The first thing, though, I want to start off and say, silence is not preferred. To simply not address this issue and trust that everybody's going to know the right thing, or that we're going to be able to fall back to the default. And the default generally would be that, for example, in a corporate structure, you have to have 2 authorized signers, that being shareholders, officers, or so on, to do for it, or you might have other provisions. But to fall back to the default of the law and expect people to know and understand that is dangerous, because remember that definition that we had of ostensible authority. It is that you allowed someone else to believe they had the authority by your want of ordinary care. And silence is kind of want of ordinary care by definition. And so we need to think about how we want to do it, what we want to put into our procedures manual, to our employment manual, and I think this is important. You can do it in a variety of ways. You can do it by the title of the signer. That is, to bind the company, it has to be signed by a person who has the title of officer, the title of shareholder, the title of managing member, whatever it might be. You could also do it by approval. That is, you have a specific written approval process where a principal or a secondary approval. So sometimes we'll have it, if it's approved by a principal, we can go ahead and sign it. Sometimes we will have a provision where on a certain level, a secondary approval by a second set of eyes would be the basis to approve it. You can also have it by dollar amount, singular or cumulative, by subject matter, by duration. All of these are controls and limitations and structures we can put about it, trying to maintain some sanity around it, but by the same token, putting controls in place so that everybody in the office does not have that ostensible authority for the potential of binding the firm. It also has the benefit of really making us talk to each other and try to work things through. I want to offer up as an example one that we worked through for one of the firms that we work with. It was a large regional firm that's now an international firm. And in that context, they were looking for a means for contractual control. They had some people who were very good at contracts, who did the right thing, who signed contracts with good form work to them, good fees to them, had the right provisions. And they had other people who would sign basically anything put in front of them. And so what we did here was we put in place a provision that said, look, up to a certain dollar value and up to a certain dollar exposure, anybody can sign this, or it can sign off in terms of what's going on. So this says that anything over $10,000 or with more than $10,000 in exposure requires the written approval of signature of, and you can put a person in there. We also had in there that a provision that any contract or a contract modification with a value of over $100,000 or a duration of more than a year shall require the advanced written approval or signature of two of the following. This was the communication provision. This is where, if this really mattered and it was significant, we wanted to make sure they were talking to each other, they were talking to their colleagues, their partners in business, and making sure we were all on board with it. It was kind of a checks and balances system. What happened when they did this is all of a sudden the contractual related claims that they were facing got cut back from frequent to almost never. Because once people had to actually talk about the contract modifications, they then went to the templates for the firm that we helped build for them that had the standard clauses in it, which has been the subject of other Hall & Company material. Hall & Company also has a contract guide, if you'd like to see it, that talks about those 8 core provisions, so that if you need to build that into your agreements so that everybody can bring it to it. So that's reaching out to Hall & Company if you'd like to see that contract guide. But what this did was it said, look, if it's going to have an exposure to us up to a certain level, we want the signature of a certain level of person. We'll allow them to do it. Below that, anybody can do it. Above a certain dollar value, we want to have checks and balances. We want people talking to each other so that we know what's taking place here. So this is not an obligatory approach. This is simply an approach that worked for that firm and worked very well for them kind of on a going forward basis. Moving then from contract authority to project authority, there are really, to me, 3 driving components in all of this, and we want to lay these out as options. So first of all, project authority should be consistent and reinforced by whatever your QA/QC procedures are. And you should have QA/QC procedures in place to guide the way that you go through the project. Let me take one side step here, because first of all, I want to note that in an upcoming Hall & Company seminar, we're going to do the QA/QC procedures, how to manage it, how to manage that, peer reviews, and so on. But as we talk about this, and as we talk about many of the policies that we're talking about going forward, except with things like the contractual provisions we just talked about, we want much of this to be guidance. We want it to be aspirational, because what it should be is a starting point for any project, for any undertaking, which then gets built into the future as a better approach. So it is guidance and it is a starting point, because as we will see, and we're going to talk about this repeatedly, and remember this, that anytime we put a plan or a policy in place in hard, fast, and exacting terms, that becomes a precarious position, because down the road it could be shown that we didn't follow that procedure and we have to explain that away. The most dangerous plan to ever have is one that's not followed. Kind of as a side note in all of this, once upon a time I had the opportunity to represent a large design firm in the design and construction of a large soy sauce factory. They did exactly this. In pitching the project, they had a detailed QA/QC procedure that was part of their proposal. It's part of how they won the job because the client was reassured, the client was inspired by the fact that this firm had a QA/QC procedure for their project that was going to lead to fewer issues. Well, I know about that project because it had issues, and on about a $35 million construction budget, they had about a $7.5 million cost overrun for one category of services. I had the opportunity to sit there for days in deposition with the project manager for that particular project, so we went through a 150-page QA/QC procedure, which had been part of winning the project. And he was asked over and over, did you do this? No. Why not? Because I didn't know it existed. Because what had happened was there was a QA/QC procedure for the project in place at the time of winning the project that was never passed on and actually became a part of the project. So you need to have a QA/QC procedure. It should be aspirational in guidance, but it should be something that's in place to truly be followed and make things make sense. The second component in terms of any project authority needs to be consistent with the licensing standards for responsible charge. It's one of my great frustrations in life that none of the state provisions for sealing and stamping documents are the same. We've been through this before in Hall & Company. We've done actually a webinar on it where Washington, Oregon, and California, in the case study that we work from, each have different stamping and sealing guidance for engineers. They're close, but they're not identical. And that's true of actually all of the states in the country. But we need to make sure that whatever we have in project authority and how we're pursuing that ultimate act of stamping and sealing is consistent with those standards, and that it is consistent with the general overall principle that the person stamping and sealing should be in responsible charge. Responsible charge means they've reviewed it at appropriate milestones and had the opportunity to have input and make changes along the way. And then finally, we want to take a look at the opportunity and also the burden in terms of the contract and the general conditions, establishing the procedures for official communication and direction. Going back to the example that I talked about, I'm going to build this in here for you in a moment, but that ferry terminal project, had we had this in place, had this been followed in that particular project, we never have those issues on there. And so this is exactly what I like to build in. I like to build in this as a part of the general conditions. I like to build it in, if I can, in the contractor's agreement with our client, and failing all of that, simply into our general conditions. Because what this says is the contractor shall rely on directions or information received from architect only if received in a written form signed by architect's project manager or an electric form from architect's project manager, and specifically referencing this section. What we're saying there is it has to be signed and in writing from a particular level in the company to become that official project direction. Simply emails and communications and texting and blogging and all of that that can take place doesn't become that official binding direction. It has to be at this level. And so this is a structure to put in place. We need to have all of that communication. We know how prolific people are in terms of their email content and the blogging and the project websites and all of that. But for it to be something official that could lead to a contract change, a financial consideration or issue, we want to make sure that it's occurred at that particular level. So that has to do with the authority, both on the contracting side and on the project side. Let's talk about the next phase that really can come into this. And this is the one where you could at least look at those AIA lists that we looked at earlier and say, hey, they got that covered. They have the standards there, and they're building in sections for, performance and training and managing all of that. They've got training and professional development as a part of it. The reality is, if we look into the details of that, if we look into the details of most policy manuals we see, they really don't have it. I think they are fundamental and important. And these have been fundamental and important to me since at least the late 90s, because I lived through a case where had this been in place, we would not have had the issue. In particular, in this particular project I'm talking about, my client, a large architectural firm, was designing a marquee City Hall project. The City Hall project was something in the neighborhood of 300,000 square feet. The project was going forward, and about 6 weeks before the design documents were going out to the street, they had to bring on additional staffing. They had to bring on additional staff because they had too much work going on, so people had to be put over onto other projects to handle that, and a new staff brought in 6 weeks before going to the street for final bidding. Now, we could second guess the judgment of all of that, but it should have worked. It should have worked had the onboarding process we're going to talk about later gone correctly and had this been in place. Because what you will see here is we have a number of standards on the left-hand side. Software and technology. What are we going to do? Codes and regulations, contracts, communications, stamping, and sealing. I want to emphasize that software and technology part because you will also see on the other side I've got standard modifications. We have our standards over on the left. As with anything that we are doing, these are supposed to be guidance, remember. They are a starting point to be modified to meet the needs of the particular project. Well, in this particular situation, they brought in the new architect. The architect had been working in other firms for somewhere between 3 and 5 years, went to a great architectural school, had the right credentials, but came in and was trying to work with new software. Also maybe had a different experience at his prior firm in terms of what they were using. So this particular architect, in order to follow his past procedures and experience, as well as to make it look good, without checking with anybody, without asking anybody, modified the rounding factor in the electronic programming for the project from a 64th of an inch to a 32nd of an inch. I mean, we can't even hold our fingers that close together and see daylight between them. Doesn't seem like much until you go over a 300,000 square foot building constructed totally of concrete, steel, and glass. And those rounding differences meant that when the design hit the street, it didn't close. And it took about 6 months to figure out what the issue had been, to reverse that rounding error, and it all sorted itself out within 3 weeks. But by the time that had taken place, we'd lost the time to do the initial construction. We were in a fast track context and we were into the rainy season, and that led to the claims that we had there in that regard. The other thing I want to talk about in terms of procedures. So we have the standard side, the procedures side. How do we change things? How do we change those standards over on the left? That's number one. Number two, how are we going to make sure from a QA/QC, a project management, an appropriate responsible charge, a client consent and informed consent from the client, how are we going to take those milestone actions to make sure that we have all of that taking place? And then the record keeping. Those to me are the fundamental big three procedures that we want to have in our playbook that everybody is following out there. So I want to give you some examples. When we work with Hall & Company, we try to give some things away so that people understand. These are drawn from some of the policy manuals that we've put together. I actually have drawn this from a policy manual that I just put together for a firm about 8 weeks ago. So first one is, let's talk about how we're going to do the design. And it's going to be performed on firm-owned equipment and using firm software. You're not bringing in your own program. You're not bringing in your own separate device. You're not working at home on it on something else. You're going to do it on the firm-owned equipment and software. Fundamentally important for two reasons. Number one, and most importantly, for the integrity of the design, making sure that we don't have programming glitches and other things like that taking place or incompatible software. And I've seen that happen. Number two, to maintain the ownership and control over the work product, as we're going to talk about. Then we get into this code issue, to this programming issue, where we're going to be very clear. Except as authorized or directed by the principal in charge, all design shall be performed using the following programs. And in that, we are identifying programs and any modifications to that. We then go on to say, for each of the foregoing, the design shall proceed with the default settings, except as set forth below, or directed or authorized by the principal in charge and communicated to the project team as a whole. Obviously, I drew this from the experience of that City Hall project I talked about. Because had we had this in place and we'd identified the software, we'd identified the factors that we are using in our firm as our default, and we had said that we're only changing that if everybody knows what's going on and it is approved, we wouldn't have had an issue. That literally would have saved somewhere in the order of $3 to $5 million in terms of claim issues on that particular project. Second part we talked about in terms of standards is the codes. And codes are precarious. Codes are things we need to deal with. And we want to be very clear. And what we've done here at the beginning of this is we've said, codes, regulations, and standards applicable to the project shall be set forth in the agreement. And yes, I believe that we should absolutely identify and set forth any of those in the agreement with the provision that if the client later wants to add something, or if building officials add something, or it comes in somehow else, it's going to be an additional service. But that is a fundamental educational starting point for any project.
of course, and also is confirmed by authorities. So I'm going to start with the contract, and then I want to go confirm with the authorities in terms of what is out there. That's the starting point. The second part, this second paragraph here, let me acknowledge right up front, this is a little dangerous. This is a little out there, but I also think we need to deal with it, because one of the great ambiguities is, how do we deal with changes coming up for the codes, anticipated changes in the codes or the standards that are out there. About 3 years ago, I arbitrated a case. We took about 3 weeks to arbitrate the case on a project that had been around for 15 years. It started in master planning. It went through budget halts. It went through modifications and all of that. The original design that the project started under, the original permitting for the project, was the 2002 building code. By the time the project was complete, we were in 2014. And the question became, one of the counterpoints as we sought to recover the unpaid fees for the architect was, well, you should have updated our project to meet current codes as of 2012 when it was built, and not under the original. Fortunately, we were able to convince the arbitrators that the original code, absent a change in services, would apply, but we need to deal with that. And what we're trying to establish here is a program to say, hey, we're going to look at that. And then it is the client's input. It's the client's opportunity. One of the papers I've written once for the AIA Trust at their request talked about technology, innovation, and sustainability in design, and how we manage that, because those are constantly changing, right? Well, that's the same thing with codes here. And after I wrote the initial white paper for that, the AIA came back and said, Dave, we want you to add a first chapter. We want you to add something new to talk about the concept of informed consent, because these things are changing. And if they're going to change and we're going to adapt and we're going to move forward, well, then the client has to sign off on it. The client has to give us that informed consent. If anybody's been to a doctor recently or an emergency room, you know how many times you have to sign off an informed consent to do that. Well, the same thing works for us. And we've talked about that before at Hall & Company programs and the printed material they have, because ultimately, whose project is it? It's the client's project. And so they should be the one advised and making the decisions. Do you want us to do an additional service to account for these changes that are coming up? Or are you good with the permitted code sections that we have out there, and then getting the client sign off in that regard? We were successful in arguing that it was the original code. Had we had the client's concurrence and sign off at the milestones along the way and advising of them, the informed consent that I just talked about, we would have had absolutely no issue in that regard for what was taking place. Informed consent, keeping the client advised and evaluating it. So this is a challenge from the standard of care. I think this is the best practices approach, but it is one that you need to stay on top of and manage. That's why I like this best in a policy manual as opposed to being a represented or affirmative service out there as a part of your agreement. Let's talk about how we make this happen, because if we have these standards and we have these procedures in place, how are we going to implement them? And it really takes place in two components. It takes place in the initial onboarding of any staff. That was the missed step for that firm when they hired the new architect. They did all the right things, talking about, paid time off, leave, benefits, salary, all of that. They did all the pure HR functions as we looked at it. What they didn't do anything about was, how do we do business? What is our approach to the project? What is our brand X approach? What's the way we do things? What software do we use? What programs do we use? What is our approach to internal reviews, QA, QC, and how do we go forward? That's why this policy manual is so fundamental. Because if you have a policy manual like we're talking about here as a component of your documents, you say, here it is. Here's the way we approach projects. It's aspirational, it's guidance in some regards. In some regards, it's absolute. It is guidance as to project delivery. It is absolute as to contracting authority, enforcement, and stamping and sealing is probably the way to go. In that, the other thing to do is to actually have an onboarding interview. Again, had they interviewed this architect in my City Hall project and said, hey, what's your experience? What programs have you worked with? How'd you do it? And have a process of doing that, of confirming and validating, well, then we would have been in a better position, and we would have been able to backfill the missing things through training. And you will note that my last issue here is acknowledgement. Acknowledgement of the policy manual. Acknowledgement, for example, what we do for a lot of firms is that they've filled out their experience background sheet and signed off on that, and that they've gone through the appropriate training as we have decided to do it. That's onboarding. That's bringing on the new staff. That's bringing them onto our team and making sure they know our playbook. Here's the problem. Things change so much over time, and we evolve in practice. As you were told at the beginning, I've been doing this for over 25 years. I go back before fax machines. I go back before email, texting, and all of that. Things change. Standards change. Certainly the technology that you work with changes, the codes that you're working with changes, and so as a result, we need to have regular reinforcement of these policy manuals. Here's the problem in all that. People get busy. People don't show up. And some people think that they are above all of that. And that's mostly you principals that think you're above all of that. You don't want to be in the room. You have other things to do. And I will tell you that to be a part of a regular and frequent reinforcement training and updating on policy manuals is probably the most important moment that you can have for being present in your firm. You are there as a team. You are there to hear what other people are saying about it. You are there to reinforce what is taking place, and you're actually there to learn yourself. So mandatory and all. I have those in quotation marks because I recognize what a challenge they are, but that should absolutely be the approach. I will confess to you, my firm doesn't do it correctly. Most firms don't do it correctly, but you need to do that. You need to have a reinforcement opportunity for follow-up, and then you need to, again, have an acknowledgement, a sign-in sheet. Who was there? Who was a part of the process? So that we can show that we've been establishing these procedures. I cannot tell you how fundamental and critical having something like that in terms of training becomes and goes to if we're trying to defend the standard of care, to say that we were doing the things appropriate for our industry and what's taking place out there from that perspective. So we've now gone through business authority. We've gone through the issues of performance standards and guidance. Now I want to get to what is really one of the thornier topics. It's the harder topics, but it's really important. It has to do with that intellectual work product. As I've written on this in the past, and as you all understand, the reality is that your firm and all firms, the real capital exists in two places. It exists in the brains and the know-how of the people who go home every night, and it exists in the computers, the software, the thumb drives, the laptops, or whatever that either exists in your office and on your system, or again, walks out of your office every night. This really becomes fundamental on two levels. First of all, it's fundamental on the incoming level. When you hire somebody new, when you bring in a lateral, when you do something like that, there are two things for that. What's the content? What are they bringing into the equation? Are they bringing files? Are they bringing information from their past experience? Are they entitled to bring that material? And what appropriate attribution do they take for the work that they've done in the past? It's important because you don't want to run afoul of their actual role and what they've done, because if you do so, you could be accused of misrepresentation. It can also create issues with the other firm. We also have the unfortunate reality that not everybody is going to stay forever. And when they leave, it's not really fair. We don't want them to walk out with all of our intellectual capital that we've invested in, that we put into place, and we want the attributions to be appropriate afterwards. I probably get involved in more contest and litigated issues about the outgoing content and attribution than any other internal issue in firms. So it's important. And to manage that and have it in place is important. Now here's the fundamental reality. If we have this as a part of our policy manual, we're probably in pretty good shape. If we have been silent in that regard, we really don't have a platform for going forward with that and managing. So we want to build through how to do that. And I want to give you 3 slides here that have content and how it comes together, and I think the appropriate way of doing it. And so what we say is all design content existing within the firm or its systems as of the time of employment. So if it existed before you came here, or created by any employer or agent of the firm during such employment, shall be and remain the sole and exclusive property of firm in its own right or as a work for hire. In its own right or a work for hire. Work for hire is a technical legal concept under copyright, trademark, and patent laws that says if you are paid to create something, then the person who paid you owns what you created. Otherwise, the default would be that the copyright would go to them. So this is the starting point. The next provision says, and you're not going to take it, The employee shall not take or convert any such design content, including but not limited to, and you can make this list as long as you want. I just put, I believe, 6 of them here as an example, with the important part being including but not limited to, for any purpose not directly related to the business of the firm. So this works for people leaving. This also works for people during their time of employment. We're going to get to that moonlighting concept a little bit later on, but they can't take it for those purposes. This is, again, one of the reasons that it's so important that we have a provision that everything done at the firm will be done on firm equipment using firm software in terms of what's taking place out there. Here is the catalyst for the departing moment and how we're going to do it. And this is also a good faith moment. This is part of having a good relationship, even with departing employees and departing partners, and how we're going to do it. And it says, at the time of employee's departure from the firm, employee and firm shall meet in good faith to reach agreement for the employee's professional credit. That is, what can they claim they did? If they were the project manager, they can't claim to be the principal in charge. If they were doing the drafting, they can't claim to have been the project manager. But by the same token, we want to let them say that credit, as well as any right to take, use, or access any of the firm's design content. So what we're saying there is, if you think you should take something, if you think you're entitled to take something, then we're going to sit down, we're going to meet about it, and we're going to try to work it out in good faith. Good faith being reasonable. However, we have the provision at the end that the decision as to the right of access to and use of any written information shall be at the firm's sole discretion. So this says, hey, we're going to sit down, we're going to talk about it, we're going to try to treat you appropriately, we're going to try to work this out so that we can all shake hands and go forward. But the ultimate decision as to the right of access and the use will be at our firm discretion. Now, there can be some variables in all of this. It could have something to do with client ownership, transfer of other projects. We'll come to that in just a moment in terms of some of the things that are out there in terms of competition. But these 3 elements, I believe, set it up. Number 1, that it's going to be owned by the firm. Number 2, the employee is not going to convert it to any other use. And number 3, upon departure, we're going to meet in good faith and try to resolve it and work it out and then reduce it to a memo or a confirmation at that point in time being acknowledged in terms of what is taking place. The onboarding process. So we've talked about the departing, because that's the part that tends to become most contentious. The onboarding part can become contentious if the prior firm comes after you, and that happens. And I probably get 1 to 2 of those types of cases a year where a firm that lost somebody is going after the other firm, saying that they're using inappropriate information. So as a part of your onboarding process, I believe you need to have a vetting and a verification process. You need to have that employee say, here's what I'm bringing. They then need to verify that they have the right to use it and the ownership of it. That you want them to be the one to authenticate and say that it's there. You also need to look at it from your IT capacity and make sure that it is system compatible, that it is not, that it's run on a software which is consistent with your software and neither older nor newer, or that it can be converted, that it is free of defects, malware, all of those sorts of things. You need to go through that process. Once you've done that and verified and have them sign off that employee acknowledgement, to create a separate copy of what was brought on. You create that separate copy of what was brought on in case you have a bad issue coming up and you can trace it back, or in case the company from which they came from makes an argument that it should be coming against. So verification of ownership, compatibility, acknowledgement, and a record copy. Those would be the onboarding procedures, which are so fundamental and critical to what we're taking place. In terms of that acknowledgement, here's a template for it. This is one that we have used from time to time. This is one that we think is good. It affirms that they have the ownership rights to use from past projects it has, and will introduce into the firm. They also, in the last paragraph, affirm and verify that any representation as to past work and the employee's role in it, should be it, is and will be accurate and complete. So we have a provision there saying, hey, look, they own it and they're verifying it, and they're promising that any representation as to their past work is accurate. we also have, with respect to the ownership rights, we want to make this one have teeth, because this one can become a big problem. Because imagine if you bring in something where somebody claims you didn't have a right to it, and it's brought into your system, and it starts to be promulgated throughout your system. To unwind that can be a horrendous task. And the worst case scenario would be you'd have to shut down your entire system and start over. So we want to make sure the employees understand how significant that is. And so we are actually asking them to indemnify, hold harmless, and defend the firm against any such claim. Now, I recognize that that might not be very valuable, because if we get into a genuine and huge dispute about this, most employees aren't going to have the wherewithal to honor most of that indemnity, hold harmless, and defense. But it is there to make clear how serious this is and how important this is as a fundamental building block for where we are going into the future. So that has to do with the design product. That's half of it. The other half of it is the business information, client lists, rate sheets, financial information, internal procedures, programming. I have one structural engineering firm that I work with very closely, which has done their own structural engineering designs internally. They've come up with calculation softwares and modifications. They had an employee leave and walked out with the whole program. We had to go claw back and fight it. And so what we are saying here is the firm has a material and protected proprietary interest in its business information, including but not limited to, and I've listed a number of elements there. You could add to those. You could be more specific if you had something specific in terms of a particular program, to be clear there that you have that listed. And they're going to treat it as confidential and shall not use or disclose it for any purpose not part of the firm's business, either during the employment or thereafter. So again, having this as a part of your policy manual, which is acknowledged by the employee at the time of hiring and in the regular reinforcement thereafter, is critical to protecting that information. Absent this type of a provision, it's going to be a very difficult clawback that you might have to go through, and we want to make sure that we have the provisions in place to do that. So, moving on to our next chapter, we've talked about records and communication, the where. No, we've talked about rather the protection of information. We want to talk now a little bit about how to manage communications, the records, and make it work. And we need to have a policy about this. I am sure that at least 3 of you listening, and I know it's more than that, in front of you or somewhere near around you probably has a spiral notebook or some sort of journal where you keep project records. You probably keep multiple project records in it. You probably keep a couple personal notes in it. The question is, how is that going to be used as a part of the project records? I had a case a number of years ago where I was representing an architectural firm, and on this project they got into a dispute with a school district over 5 different projects, and particularly with respect to the financing and master planning of the project. The project manager, an unlicensed architect they had running the project, kept track of his entire life in those types of notebooks. He kept track of the projects. He kept track of other projects. He kept track of his local bar tabs and a few other pieces of local information that we would not want out and disseminated publicly, or at least he wouldn't. And so he locked those up in his boathouse and would never let us have access to it. So the fundamental issue that drives all records and communication is it is the firm's information. If it is done in the course and scope of employment, if it relates to a firm project, it is firm information and it needs to be accessible to all. It needs to be verifiable and reliable. And we have 2 columns here. We have the electronic and we have the hard copy, and no 2 firms are going to be exactly alike in this regard, but you need to make a plan. You need to make one that's going to work for you. And if you're going to go down one path or the other, or a combination, the information needs to be centralized, and the information needs to be accessible to all. It also needs to be comprehensible and searchable on some level so that we can find the information that's out there. And we can talk about whether it's secured or it's efficient. I simply have a lot of questions here, but the bottom line is that you need to build a policy and have it in place to manage all of that. I want to give you some of the thoughts that I would have in place in terms of the communications, in terms of what's out there and how to manage it. Just these are the general guidelines that we put in place when we're putting in place a documentation program and guidance. I think that's another one of the Hall & Company webinars we've done in the past, and I'm sure we'll do it again sometime soon. Drafts. There is no good reason to save internal drafts except maybe contracts. I had the opportunity once when I was giving a version of this talk back in North Carolina, and I was in front of an engineering firm, and there was an engineer at this point in time who raised his hand and said, I want to save all of the internal drafts. And I said, why? And he said, so if something goes wrong, I can show that it was his fault and not mine, which made exactly the point. Because if you've just shown that there was a mistake and a fault and we knew about it, we've just shown that to the other side and the outside world. Confirmations and verifications we've just talked about. Confirmations of our review process at milestones, confirmation of outside information, and confirmation of client input and approvals is so fundamental and critical. I will tell you that there's probably no more important information than the client-informed consent. If we look at the AIA B101 and the phases that it goes through, you will note that each opening paragraph for design development, contract documents, 50%, and all of that, each one starts with following client's approval of the preceding section. Yet we almost never have written confirmation of that. It's incredibly important to what we do. And we want to build in other communication standards, particularly for email, and now I have to say texting and other electronic forms of communication. I just want to give you a little bit of a highlight in terms of what maybe I think should take place in email protocols. This is what I try to implement in my own firm. It's what I've tried to implement in a number of firms for reasons that we've seen in terms of things gone wrong. Have an appropriate subject line with criteria. We should all be captioning our emails the same way so they become searchable and understandable from the subject line. Project, subfile number, content. Intentional recipients. There is no greater sin in the world of email than reply all, and it should be used judiciously. Avoid serial strings. From my perspective, if you have not solved or completed an email sequence in 3 to 5, you need to restate the issue. Oh, by the way, my record is 23 pages, that is, where in the course of this string of emails, it covered everything from RFIs to change orders to the company picnic to an invitation to go to the 49ers football game, all in the same email that became a part of the record out there. The other thing is using of a footer. And I believe footers and good signature lines are one of the most fundamental risk management tools with email because it can so readily be communicated. I have a white paper that I've written. I believe it's up on the Hall & Company website. If not, reach out to them. It's called Email as a Project Communication Tool, Loose Fingers Sink Ships. This is the message that ultimately comes out of it, that we should have controls over this. And it really reinforces some of the things we talked about. This message is intended solely for the recipient identified above and should not be opened, read, or utilized by any other party. I cannot tell you how many times in litigation or claims I've had the basis of the claim be a forwarded email that somebody said they relied on it because it simply had the name of the architect or the engineer at the bottom, no controls over it, and it was simply forwarded on to a third party who said, hey, I relied on that. Therefore, because I relied on it, it turned out to be wrong or I was damaged by it, I'm entitled to money. I once had a structural engineer's evaluation of a structure. They did it by email report. It was forwarded on to the purchaser of the project. They bought the building for about $17 million. Turned it out, it needed about $2.5 million of structural updating and enhancements. They turned around and tried to sue the structural engineer for it because they said they had received the email with their evaluation and had relied on it as a result. Had this message been there, we aren't in that. Second sentence here is consistent with what we've talked about earlier because we know people are going to go back and forth with the information, right? And we talked about the clause to put into the general conditions. We talked about the clause to put into your general notes. Well, this reinforces by saying this message shall not be construed as official project information or direction except as expressly provided in the contract documents. So we have a procedure in place. We have controls about it. I want people to talk about the project. I want the project to evolve. But I want to do it in a way that makes sense, where we then can make the ultimate decision. Is this a change? Is this something that can impact schedule, cost, or the project as a whole? The other thing that I think is so important is to equip your teams with templates. And so in the policy manual, when we put these together, particularly electronically, we will have cross-reference to templates because I want people to all have the same tools to work with. More importantly, particularly on the right-hand column here, the challenges, I don't want them to be making it up on the fly. I don't want them to be doing variables. I want to equip them with the standards. If they see a site safety issue, I want them to know what to do. I want them to have a starting point that they can then take as their guidance and modify it. The same thing with respect to value engineering, non-conforming conditions, all of that to equip them for what's taking place. So we can have the standards, the routine on the left-hand side, shop drawings, RFIs, and all that, where we should have standard templates. On the other side, we want to be able to manage those issues in terms of what's out there. Well, I apologize for that. Those noises I didn't know were there, so thank you for that. Filing systems, we've talked about this. Centralized filing of all official records, no personal files. We should be absolutely clear to the world that there is no centralized filing, there's no personal file, that everything you do on a project is out there. And we want to clean them up and use them as a part of a good archiving system where we are being prompt, we're cleaning them up, and we are saving the right records. I once had the experience of producing 127 boxes of documents on a project. As we went through that, over the course of the 127 boxes, we saw 32 copies of the same meeting minutes, unmarked, unnoted, anything like that. It was simply repetitive and out there. Moonlighting, I want to hit two final topics here, and then we're going to close things out in about the next 3 minutes. And please send in any questions that you have, and we'll try to respond to them. But moonlighting is obviously precarious, because if moonlighting takes place, and particularly if they do so using any of your technology or background, it could lead to liability if something goes wrong, and you're not even getting paid for it. So you should disavow it. You should disclaim responsibility. You should require the clients, the employees who actually go out and do it, to defend, indemnify, and hold you harmless. Again, knowing that there's limited benefit to that except to make it clear, and non-use of firm assets. This is a sample of the moonlighting disclaimer that we will use, which simply says that we're not taking responsibility for anything except that done under a firm-approved project and contract, and we are not responsible for outside activities, and they are not going to use firm assets, materials, and equipment for those outside policies in terms of what's out there. We simply need to keep that distance. We need to respect that and enforce it. And then finally, I want to talk about competition for just a second. The reality is we can't talk about this in a comprehensive fashion because every state has very different anti-competition laws. What will not fly in California, I know from personal experience, will fly in Illinois and otherwise. The reality is that you can put controls around it, you can be proactive, and the more narrowly tailored, the more likely it is generally to succeed. I want to thank Hall & Company for sharing this hour with me, for giving me the time to work with them on this and other projects. We probably are not going to have time within our hour to get back to with questions. We will read every question, every comment, and as appropriate, get back to either the group as a whole or the individuals in that regard. So with that, I hand it back to Ms. Ledbetter.
Thank you, David. You bring such passion to everything you do, and we truly appreciate your partnership. Our clients totally value you, so thank you for everything you do. As far as this webinar goes, if you have questions or you need help with your certificate, please email lledbetter@hallandcompany.com. For those of you who are AIA members, the presentation's been approved for 1 learning unit of continuing education credit, and we will report that attendance to the AIA on your behalf. Please email your membership number to me, and I will go ahead and get that information over to you. For your certificates of completion, we will email that link to you tomorrow, and you'll be able to get that completed upon completion of the quiz. Our next webinar is June 6th. This will be a failure analysis and the professional liability claim process with John Lowe of Lowe Consulting, LLC. Hall & Company's gained a lot of practical experience over the last 27 years of working with design professionals, and we like to share that information with you in programs such as this, as well as on our website, which has risk management and loss prevention information. Please visit that for our resource library, our webinars, and reach out to us. We love talking with you, and we'd love to help you. At your renewal, please feel free to give us a call with any quotes. We'd always be happy to help you. Thank you for participating. Once again, thank you for David, and we look forward to chatting with all of you again.